Welcome to this episode of Compliance Lab with myself, Sarah Sawyer, an attorney at Offit Kurman, and Rose Mesina, who is a director and economist with Resolution Economics. Today, we're continuing our conversation. This will be our last episode on reductions in force and terminations as it relates to data, legal compliance. We've been talking so far, and we've been following the process about getting a handle on your data, trying to figure out what you have, what you want to have, how to organize it, how to monitor it, keep track of it, maintain it, how to use it as part of the reduction in force process in your regular maintenance, how to really spot and have a good idea of what's going on within your company using data as it relates to your employees. And then going through the reduction in force process. All right, well, we've gone through that process. So transporting us into a place in time right now where all that has happened, you've done a reduction in force, the employees have gone on their way. Well, now they've decided they want to sue you for something, right? So sometimes that happens. Obviously, we've talked a little bit about there's ways to try to avoid that happening, mitigating your risk, trying to maybe ahead of time do severance agreements or separation packages to try to prevent that risk, or lots of different things that you can potentially do. But often employees are terminated or laid off, and now they're left trying to find a job, trying to pay their mortgage, trying to figure out what they do next. And some of that might be talking to an attorney and then saying, well, you know what, I don't think the company did this correctly, or I don't think that I was paid properly, or I think I was discriminated against. A lot of different things that can happen, a lot of different reasons. A lot of the ones we've been talking about have been mainly around discrimination and wage and hour. So we'll kind of stick in that category. There are other categories, but I think those are pretty relevant to our conversation on the data side and compliance side of things. So when that happens, and obviously both you and I, Rose, we deal with this often with our clients, and they come to us and they're upset, or they're just like, oh gosh, okay, this is a problem we have to deal with. What do we do next? And assuming that you've done these things, you've got the data, you've got the situation, I think there's two categories that the data really can become useful in. And one is obviously fighting the claim itself. So if someone has made a wage claim or a discrimination claim, and maybe you have the data to support, well, actually, you know what, you're wrong in what you're asserting, and here's why. So that's one category that I'd love for you to touch on. And then obviously we can talk about, well, let's say there is some type of liability there and they're claiming some astronomical amount of damages, which is often the case, at least from the employer's point of view. Then how do we use the data in that context? So starting with the case itself, I know we alluded a little bit in prior episodes to the ways that you can use the statistical analysis and different things, but what's the starting point on potentially fighting the claim itself?
Yeah, like you said, ideally at this point, you've done all the prep work and assess your risk, and you know where they are, and you have documentation to support all of your decisions. If you've done all of that, usually you're in a better position to effectively defend against things like a discrimination claim, for example. So let's use that as an example. One way that your statistical analysis, which again, at this point, hopefully you've done a little bit of and you're aware what that looks like, is then you can show your findings saying, look, based on the statistics, based on the data and all the numbers that we're seeing, the decision to terminate this employee is not actually, there's no relationship because of their age or gender or race, for example. There's all of these other job-related factors that have gone into it, and we do see those factors being reflected in the statistical results, because these are all data points that can come together, and the analysis will then report it in a way that you can see what the relationship between being terminated and all of these other factors, what those relationships look like. Once you have that, then hopefully by this point you could pretty easily point out that, look, this decision, the biggest driving factor is actually job related, and it's not related on someone's protected characteristic. So that's one of the ways that we've seen the data being used to successfully defend against any of these claims and resolve all of these disputes earlier on, and usually in a way that's favorable to both sides, because you don't really want to spend all the time and money and resources to go further into litigation. Sometimes it happens, but most times it's a good outcome to resolve it pretty early on.
Well, it's an easier when you can point to data that helps disprove something that someone's claiming. It's helpful because we all have heard the he said, she said battles, or when there's stuff that's like, I'm going to call it squishy, that's a little more just fact-based and a little bit more subjective, and it relies on credibility, because when we don't have data, the other types of evidence we might have are more like a storytelling, narrative, credibility type depositions and testimony, and why they might think that these things, they might have been discriminated against. Or so if we don't have the underlying data and we don't have other things to support it, then we're stuck in that category, which is fine. And that is evidence just like anything else. And that is something that comes up in these cases. But it's much more time intensive and expensive dealing with those. And sometimes it's unavoidable. But if you can also have the data that supports your position, also the documentation. As a lawyer, I love when people document things, right? If you've got good documentation that's contemporaneous, like before these decisions were made, around performance or around how these business decisions were being made before the individuals were layered in, and those types of things. Those are just a couple examples. But when you've got some of these things that are a little bit harder they're more objective, they're stronger in nature, they can help with a quick resolution, help save you money, both from a damages perspective, but also from an early resolution. Because obviously, as you dig into these things, and anyone who's been involved in litigation knows that the costs add up fast, especially when you're having to take depositions and deal with fact witnesses and things. So having that early on, being able to put something strong out and being prepared to make those arguments to an opposing counsel to really maybe quash their thoughts that, oh, well, maybe this is going to be a huge payout, that will really help as well. But on the damages side, so sometimes there is liability. Sometimes employers have done something wrong, or they're just, the fact finders find that there's an issue. And then we're in the damage category. As far as how we use the data there and who gets involved with assessing the damages, what are some things that are relevant there, Rose?
Yeah, like you said, sometimes it gets to a stage where there are damages that need to be paid out. The question is how much, right? Or the biggest question really is how much.
I think that's always top of mind for most of my
Exactly.
clients.
In my experience, and I'm sure as well as yours, typically the plaintiff will retain their economic expert, who essentially will do their calculations and basically say that the plaintiff is entitled to large sums of money because of the employment action, so termination, let's say. And in my experience, the underlying assumptions to these economic loss calculations, depending on the expert, of course, some of them sometimes are not supported by the data or do not reflect the realities within the company or the external labor market. It doesn't account for things like, actually, the plaintiff wouldn't have stayed at this company forever. It's probably a much shorter time period. And you can see that by looking at trends of previous employees that have also left that had similar characteristics, similar jobs, etc., similar skills as that person. Because think of an example where you're a company and you have all of these people that have really high skills, and you're seeing a trend that these people do move on to somewhere else that's more high, especially in the tech world, for example. They have all of these skills. They have a bunch of other options. You might have a few employees that, are just going to be with you forever. They really love working for your company. It's a good company for them. But when you're looking at the data, you have to consider the trends and the possibility that actually this person probably wouldn't have stayed forever, and therefore we're not really responsible for all the money that they would have accumulated at the company. What a company can do in that situation when they're seeing all the large sums of money that the plaintiff and their expert are claiming that they're entitled to is you can look at it yourself, or have, obviously 100% consult with their counsel, but also potentially retain an economic expert yourself to really just help you assess whether these assumptions are supported by the data that you already have. And ideally, by this point, because we've talked about in the previous episodes, to be prepared and have your data ready, your economic expert can have all of those data, study them, and see what can be helpful to support like a more robust economic loss calculation, which typically result in much lower dollar amounts, which I think from the company's perspective is better.
Yeah.
Better to pay out a lower amount, but also not just because it's a lower amount, but because it's the reality. It's what's supported by the data. It's what's fair.
Yeah. And I think there's always a cost benefit analysis, looking at experts, looking at the costs associated with that. But especially in situations like we've been discussing on Compliance Lab, is especially when you're dealing with a larger scale, because what might happen is one employee might make a claim, but that there might be either a class action involving all the employees who were impacted and they all might band together, or all the older employees that were terminated. So when you're dealing with a reduction in force that's a little bit more sizable, especially in those instances, because you're dealing with a lot larger scale. Even at the beginning of a class action, you might be able to use an expert also to try to make people seem dissimilar, like they might not actually be sitting in the same seat. And that also ultimately impacts damages and costs. So a lot of that has to do with the dollars and doing that analysis and saying, yeah, an expert costs up front, but what are they going to save you ultimately in pushing back? Because obviously any plaintiff, any employee who's seeking to recover damages is going to try to get that number as high as possible, which is their prerogative and understandable given that they're engaging in the process and want to maximize their recovery, and the attorneys want to maximize the recovery because they get paid for that as well. A good expert can really go a long way. And just to throw back to what we've been talking a lot about on the shows, as far as we'll call it a show.
I like that.
A lot of it is that the more prepared you are, also the more efficient that's all going to be. Because ultimately, if you've got things packaged in a way that is easy for an expert to go through, understand, analyze, or you've been working with someone who's helped you with your data and information over time, that's going to go a little bit more smoothly and easier than if you obviously are creating it after the fact. Because a lot of the stress related with litigation that I see is the time, not just the money, that the employees of the organization have to spend on this instead of meeting strategic objectives and doing their full-time jobs, which is whatever they need to do on a day-to-day basis. They have to end up doing a lift. And especially in larger companies, employees who are in those roles of having to collect that information and spend that time might be a little frustrated when they're like, well, if we would have been a little more prepared, maybe I wouldn't be having to spend this time.
Yeah. And
something to
if
consider.
you're in that situation, you're having to do it fast to respond to all of the court deadlines, if any. But just really quick, Sarah, going back to your earlier point about the expert as well, is your expert also doesn't need to offer, depending on the situation, there doesn't need to be an alternative calculation. It might be that you just hire an expert to look at whether it's reasonable, and your expert can say, yeah, actually they've made some good points here and this is probably the best that you can do anyway, and not necessarily have to calculate a different thing. If they did have reasonable assumptions, then that's something to consider as well. It doesn't have to be a full-blown offering a different number. It's just looking at whether it's reasonable and it's acceptable.
Yeah, that's a great point, because sometimes you look at it, just like in one of our episodes, we talked about looking at it and sometimes you discover you did do something wrong, right? So it's not always that you're trying to fight yourself or fight the other side. It's just back to that knowing, right? You want to know, is this correct? And if it is, then great, you can plan around that, and then you can start figuring out what you can afford as far as damages are concerned, how it impacts the organization, what that looks like, how it's structured, all of those kinds of things, and get you to that point. So I think that's a great point to make sure we highlight.
Yeah.
Well, thanks, Rose. And this has been a great conversation on 4 episodes on reduction in force and terminations and the intersection of legal compliance and data and experts. And it was very great hearing from you and your perspective on these topics. And I look forward to more episodes.
Thanks, Sarah.
Thanks. Bye.